I've had to hear these people talk about how bad I am, all this and all that. I'm just done with it. Like I ain't really tripping about it anymore.
Next case I have is State of Kansas versus Isaiah David. Is it Dykus Solzman?
Yes, Judge. He's in custody.
Your Honor, this is the one that we have the victim's parents in the waiting room.
The victim is able to be there. If there's other people with her, they may not address the court. The victim, if she was an adult when that occurred, she's a statutory victim. Sarah, or excuse me, Jen, she can be brought in. I'm going to start with this traffic case 23 TR 3035.
Judge, I would announce this time on this case 23 TR 3035 to the charge of driving while suspended. My client will enter a plea of guilty. But the request will be that this run concurrent with a felony case that he just had at 11 o'clock with Judge Rickey, and he was sentenced to serve that time in prison.
And were these the terms of the agreement?
Yes, in regard to 23 TR 3035, Your Honor.
Mr. Dykus Solzman, is it correct you're pleading guilty to driving while suspended on or about, looks like July 23rd of 23?
Mm-hmm.
Okay, if you could answer in words, please.
Yeah.
Is that a yes?
Yes.
You understand you have a right to a trial on this if you desired one?
Yes.
On or about July the 23rd of 23 in Butler County, were you driving on a roadway or highway in Butler County while your license was canceled, suspended, or revoked?
Yes.
I find that the plea is knowingly and voluntarily entered with the advice of good counsel and find him guilty of that offense of driving while suspended.
Judge, the only additional thing I would say is, again, he had 2 felony cases since he's been in jail. He's been in jail now since April, I believe. And he was sentenced by Judge Crum on 1 felony. This morning, he was sentenced by Judge Rickey on the other. Judge Rickey, I understand, did order he served that time in prison. I don't know what that sentence was. Mr. Devaney might know for sure what the length was. But we're asking the court to run this concurrent with that felony. He'll be on parole, of course, after he serves whatever sentence that was. And so we'd ask the court to run it concurrent. Thank you.
What was the nature of these felony charges before Judge Crum and also Judge Rickey?
The case in front of Judge Rickey, it was amended and he pled to attempted abuse of a child in that case. The other case, again, in front of Judge Crum, it looks like those charges, he pled to an attempted aggravated assault.
Without giving names, were these victims that are involved in any of these cases today?
Yes, the Clarks who appear here in the courtroom, it's basically an ongoing drug out domestic conflict, and there's been violation of PFAs, a number of different charges, including the abuse of a child charge. So this is
what's the length of the charge that he's been incarcerated on, and was he given jail credit that would include any time that he's been here in this jail?
Judge, I apologize. I can't answer that. That just happened at 11 o'clock, and we don't have the notes or anything updated as of yet before the docket started. But I do know that he was sentenced to prison this morning to serve his DOC sentence. And to be honest with you, Judge, the Clarks who are here were in court. They would probably know at this point more accurately than I would.
Well, Mr. Patterson, do you know what the length of the sentence was?
It was an in-court hearing, Judge, so I could not attend. So I do not know. And I spoke to my client this morning, but I haven't spoke to him after the hearing.
It was 34 months.
34 months?
Yeah.
Did you get jail credit, and what time frame did you get jail credit?
I don't know if I got jail credit or not, to be honest.
And Judge, under the new Supreme Court rules, or I guess cases, one of them State versus Irvin, it doesn't matter on the credit for time on which case it goes to. Each case gets that credit, even if it's double credit. So because he's been awaiting trial on this case also, he would get credit. It's just the current law.
Okay, so concurrent versus consecutive, you're indicating would only be from the date of the sentencings?
Yes, Judge.
Okay. Mr. Devaney, any disagreement with?
I think there's been some remedial efforts with regard to that jail time credit estimation, but I will look in looking at the attempted abuse of a child case in that PSI. On that case, he was assessed 163 days of jail time credit.
Very well. Mr. Dr. Solzman, is there any statement you'd like to make in regards to the driving while suspended charge?
No, sir.
Well, I will impose the 6-month sentence, a $100 fine, and I'm not placing you on probation. However, it will be concurrent with the prison sentence that you're ordered to serve before Judge or on Judge Ricky's case. Well, you'll get credit for the time that you served in jail in this case, and I'll make that one concurrent with the felony case Judge Ricky sentenced you on. So that should take care of that matter. In regards to 25 CR 337, what is the plea in the agreement on that case?
Judge, this would be again a plea of guilty, violation of protective order. The agreement would be that there be no fine. He pay court costs, court to determine attorney fees, and that it be a 1-year controlling sentence, and the agreement is to recommend concurrent with his felonies.
Okay, is the victim in this case the mother of the child that was the victim in the case that he was sentenced on?
Everybody's shaking their head. Yes, Judge.
They're nodding. So I'm taking that as a yes. Mr. Devaney, is that your understanding of the agreement?
It is, Your Honor.
Mr. Deacon Solzman, it's been indicated you're pleading guilty to count 1, which is violation of a protective order, a Class A misdemeanor. Is that your intention?
Yeah. Yes.
Have you had sufficient time to discuss this with your attorney?
Yeah.
So on or about June the 5th of 2025, and while you were or the victim was in Butler County, that did you have a protective order? Was there a protective order from a district court for you not to contact her?
Yeah, there was.
And did you contact her? And,
Yeah.
and looking at the affidavit, it appears that you did so through another individual while you were at the Butler County Jail. Is that
Yeah.
correct? I do find that the plea is knowingly and voluntarily entered with the advice of good counsel that a factual basis exists, and do find Mr. Dr. Solzman guilty of that being a Class A misdemeanor. The other 2 cases, which also appear to be involved with that victim, that being case number 25 CR 184 and 25 CR 186, are dismissed with prejudice pursuant to the agreement. I will here, first of all, I'll allow the victim to speak. That she is an adult, appears to, based upon the date of birth, would have been an adult at the time of the offense. So Ms. Clark, I will hear you in regards to any statement you wish to make in regards to, and I have to be careful what let's make it an appropriate statement. Not that I think that you would be inappropriate, but I've had other individuals that were. So I need to put that in my recitation at this point. So any appropriate statements you wish to make in regards to sentence on this particular case?
First, I just want to say it wasn't just one time of violating the PFA. There's multiple in Wichita that are dropped, I'm pretty sure, but it's been multiple times. He has a pattern of violence towards me and my son. I don't know, I want you to take into consideration when you sentence him. It's a recurring pattern.
All right, thank you. Mr. Devaney?
Kind of want to echo the victim statement here, which is obviously this is a kind of an amalgamation of a number of different cases that have evolved out of a long-term stalking and harassment violence. There's domestic battery, violation of protective order. You have aggravated assault. You've got attempted abuse of a child. Pleas. This has resulted in him going to prison now for 34 months. And certainly hope that this is the end of everything, but he'll have post-release supervision and all of those matters. And I certainly think that these cases are serious and recurrent. And on top of that, you throw in a traffic charge on top of it. So it's just been a long drawn out process for the victim in this case. And I say victims plural because it is not just this young lady, it's the child as well and her extended family that's been dealing with this. Regardless, we finally, I think, have closed down his cases and got him to where he's going to be going to DOC now. And so the plea agreement that we have here with regard to packaging this up and maybe closing out these cases, I think is a step in the right direction here today. I'd ask that you adopt the recommendations we had for the plea agreement between Mr. Patterson and our office. As far as jail time credit, we're going to have kind of a algebra to do, I think, with regard to that, but we will get that calculated and have that reflected in the journal entry.
Thank you. Mr. Patterson?
Just briefly, Judge, we've talked about a 32 or 34-month sentence that he has with Judge Rickey. He was sentenced by Judge Crum, but in that case, he was diversion eligible, received diversion. I mean, not diversion, probation. But of course, since he's serving this 32 or 34 months, probation is probably impractical. So that I would think there is going to be a revocation of that case for probation. And it's consecutive by law. So it's much longer than just the 30-some months, Judge, that he's probably going to serve. So at this point, just ask the court to adopt the recommendations. Thank you.
Mr. Dr. Salzman, is there any statement that you'd like to make before I pronounce sentence?
And I mean, I'd contact her because I just wanted to just tell her I was sorry. And I mean, I wasn't trying to mean no harm or anything. And you ain't got to worry about me ever trying to contact her again. And I'm sorry for what I did. You know, I,
Anything else?
that should be it.
It's not very often a defendant, when they're hearing the factual basis and hearing the attorneys, is smiling in regards to at their sentencing. And you've been doing it quite a little bit, particularly when the victim was stating and otherwise. What's so funny about this?
That they lying on me. That's what's funny to me. They don't even know me. Like her parent, like they have the stuff they saying ain't even true. Like I know what I did to my son, but I mean you can believe him if you want to. I ain't
Well,
tripping.
you've pled guilty to an offense here today, and I went through facts, and you acknowledged those were correct.
Like, I mean, I'm not worried. I'll do my time. I'm just like, I've had to hear these people talk about how bad I am, all this and all that. I'm just done with it. Like, I ain't really tripping about it anymore. Like, they've tried to make me sound like I'm a bad person, and I'm not. My family knows I'm a good person. My family knows I love my kids. And it's just funny to me because, like, she wasn't saying none of that stuff back then. And her parents weren't even in the picture. Like, she lived with my parents and my parents were taking care of my kids. Her parents weren't even in the picture or anything. So I just find it funny now how they all switching up, how she's switching up.
Well, sir, you've had judges tell you not to have contact with her, and you seem to have just went through those
I
orders without.
contacted her one time. I don't remember any other time that I've contacted her other than when I called her in jail. I really don't.
All right. I'm ready to proceed with sentencing. Was there something else that you wish to state before I make sentence?
No, sir.
for the offense of violation of a protective order, a Class A misdemeanor, person misdemeanor. I sentence you to 1 year in the Butler County Jail. I ordered court costs and attorney's fees to you. I have considered a fine. I'm declining to do that. I don't believe you're sorry for
Man,
what you've done. Just watching here today.
I'm sorry for what I did to my boys, but I ain't sorry for what I did to her. She switched up. I honestly could care
All
less.
right. Thank you. I'm ordering that this case run consecutive to the other cases that you've been sentenced on. If I understand the general practice, you will, and you'll get credit for time served that you're entitled to on this case. That may be cross some of these other cases, but if there's any other additional time, I believe the general practice is for the person to go to the penitentiary, and once they've served their sentence there, if the misdemeanor hasn't been modified, then just come back to the county jail to serve their time. And that's what I'm intending to occur. The court can hear modification motions at that time, but based upon what I've seen here today, I don't think he is a good risk, and I don't think I think he has. It does present a danger to the public as well, certainly to the victim here. So I think he needs to have a penalty for what he did in this case, and making this concurrent with everything else doesn't do that. Counsel, any questions or other matters that I need to make a rule on?
No, Your Honor.
Nothing further, Judge. I just want to make sure we get credit for time. I'm sure Mr. Devaney will send that to me.
Right. And I think I already stated this, but 25 CR 184 and 186 are dismissed with prejudice pursuant to the agreement.
Yes, Your Honor.
Nothing further than this matter is adjourned, and he can be taken to serve a sentence.